one of the crucial or one of the most important articles in the our judiciary, governance, and the polity and constitutions overall. So why? Because of the Dr. In the words of the Dr. Babasaheb Ambedkar, also this is the soul of our constitutions. When he talk about, actually when he was discussing about the this article, especially in the Constituent Assembly, he he said that the article number 32 is the soul of our constitution. So why is it called the soul? And so vitality or its importance itself, in the words of the Dr. Babasaheb Ambedkar, says that the soul of our constitution. So first of all, the article number 32, it's about the writs. So what is mean by the writs here? The writs means the written order. The written order, or the at what kind of the written order? The article number 32 is about the written order of the court. The court, actually, as the fundamental rights is one of the key chapter in our constitutions, but as according to Dr. Babasaheb Ambedkar, article 32, without the article 32, the fundamental rights is null or nullified. Actually, it is not reality, or it is not curative or important. So let's see what is mean by our the article 32 writs. Writs is about the written order. So constitution are provisional. The article 32 is in the protected. Protection is given by the Supreme Court, and by the article 226, the protection to the fundamental rights is given by the High Court. So article 32, the soul of our constitution, it is said, really said, rightly said by the Dr. Babasaheb Ambedkar, because of the it is mentioned and it is given or protected by the fundamental rights, especially protected by the our Supreme Court. And article 226 is also one of the article which is also protects fundamental rights with the written order. It is also called the writs. Writs is about the written order. So meaning of this written order. So there are 5 types of the writs are there in our constitutions. The first one, if you see, the habeas corpus. Habeas corpus, the Mandamus, the Prohibition, Certiorari, and Quo Warranto. These are the 5 writs of our constitution. So the writs we have seen means written order, means any person in our country, any common people also can go to protect his or her fundamental rights with the help of these 5 writs. The first, habeas corpus. What is mean by the habeas corpus? The really mean it is actually habeas corpus. It is a Latin word. Habeas corpus means here to have the body. So who to have the body? Actually, literally meaning of this habeas corpus is the have body. So it protects personal liberty, as well as it protects personal liberty, and it also prevents personal liberty, and prevents the prevents private as well as the public authority from illegal detaining or illegal detaining of this someone. So it is very vital, and rightly it is one of these most important writs in the 5 writs. One of the not, but it is foremost important, because of the it protects the personal liberty of the person. Then who can use, actually is who can use, that anyone or any detained person, someone, if suppose if someone is detained, and actually he want to free from some detention, then he can use, but he is not able to do so, then he can approach, or someone can approach with on the behalf of him to the courts. So any detained person or any other person on the behalf of the detainee. So who can any person, against whom, it is another important question. So who can actually legally, if you see, the legally public authority in the form of the police or the court has the authority to detain someone, but illegally private persons can also detain miss or illegally. In such a cases, the writ habeas corpus can be used against the private person also, means when the private person as well as public authority, if someone is arrested or detained, sorry, arrest not but detained illegally, that time the habeas corpus writ can be used. So it is rightly so, said that it is most important, and it protects the personal liberty of the person here, the habeas corpus. Next one in the list is mandamus. Mandamus means we command, we give the orders. So it is used, the purpose of this, to compel the public authority, especially is it is given against the public authority to, it is actually if you see that it is a positive writs to compel the public authority to do something, actually do something, whatever the activity or whatever the duty. If the public authority fail to do something, then court or the higher authority can compel someone to do this. So purpose compels public authority to do. It can't be used the private, can't be used against the can't be used of the against the private sector as well as the president also. Means no court in India has the right to compel president to do so, because president is the almighty or most supreme power, supreme leader in our country. So president cannot be compelled to do so. So this mandamus cannot be used against. So this is one of the actually positive right to do something, because it can court can compel. We have so number of the examples where the court can compel. If suppose there is now pollution is higher AQI in the Delhi, so court can intervene and uh, order the Delhi government to reduce the pollution in the Delhi and improve the AQI in Delhi. So in such a cases, the court can intervene and compel the public authority to do positive things for the betterment of the people. Here, the prohibition, it is kind of the negative kind of the act. Here, this compelling, and another factor, another things here, the prohibition. So court can court especially, here is the actually two authorities are important, the higher court to lower court. Higher court actually issue against the this writ to lower court. If the lower court access or excess use of the jurisdiction, or the uh, it go beyond its jurisdiction in the giving the orders, so that time especially prohibition, the writ prohibition could be used or can be used by the higher courts to lower courts. I mean it is about the court's writ or court. It is in the especially curative in nature, the preventive prevents courts if the jurisdiction is overwhelmed or excess use of the jurisdiction. It is about the jurisdiction of the courts. Then certiorari, to be informed means after the, it is also about the courts, means higher court. Here again, higher court to the lower court as well as tribunals can ask, higher court can ask about if the, and same situation here also, the extra use or the overuse of the jurisdiction, means if the jurisdiction is crossed, if the someone or lower court is crossed this limitation jurisdiction while giving the any order, that time especially certiorari writ can be used, and where the court can ask in what authority, means here to be informed by which authority they have given this order, means after the order. Here is the before the order. Prohibition is about the before the order, means preventing, and certiorari to be informed, just to inform by what authority, by which law or legality, especially legality is check in the certiorari. The quo warranto again, another type of the writ here, the quo warranto, by what authority, illegal occupations of public offices, who can apply, or any citizen, especially any citizen can ask. Suppose any person, uh, suppose if someone want to ask question to the university that which authority do this, means public offices especially has to answer. If the common people can ask them questions, by which authority did this do these things or did these things, are doing these things. So in a same situation, by what authority? Authority could be asked by the someone, means any common person can ask any public officers about their by which authority they are doing so. Means if suppose in Maharashtra we have the municipal council, gram panchayat, so common people can ask why by which authority they are levying the taxes on someone, why they are doing this drainage work. So such as things can be asked here. So legality, by which authority or illegal occupation of public offices are can be asked, could be asked, check here. So these are the writs of our article number 32, and it is a very vital article. So here, as far as writs is concerned, the article number 2226, High Court has the more expansive kind of the rights as far as writ is concerned. Means High Court can ask question, mean actually means extraterritorial also, extraterritorial matters also can be handled of the High Court, while territory, within territory, Supreme Court has authority to do so. So these are the 5 writs: habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Thank you.